that this bill that we are seeking to do here today is simply trying to codify the position as it is and expounded by our judges both in the Eastern Caribbean Appeal Court and in the Privy Council. Madam Speaker, the mandatory death penalty, as the Honorable Attorney General told us, has been outlawed for now several years and is being ruled by both higher courts as being unconstitutional. The same was the position of sentencing persons at Her Majesty's pleasure, Madam Speaker. The courts have held that sentencing is a function of the courts and not the executive. This bill, Madam Speaker, sets these matters right, and I commend the government for bringing this bill to this Honourable House that is very timely to do so, Madam Speaker. The occasion should have been taken, Madam Speaker, I think, though, in the bill to also deal with persons who were insane. I did not see that, Mr. AG, in the bill. I think that sentencing is a matter for the courts, Madam Speaker, and the manner of execution should not be left to the Governor General. Because if we looked in the draft legislation that is before us, the draft bill, Madam Speaker, it says, let me find the correct section, Section 4, Madam Speaker, subsection 7, Mr. AG, and it reads, after the execution of sentence of death in the manner directed by the Governor General, and the person has been pronounced dead by a medical officer appointed by the court, the provost marshal shall hand over the remains of the person executed to his family for burial. Section 6, let's go back to Section 6, where a court pronounces a sentence of death pursuant to subsection 1, the Governor General shall direct the time, place, and manner of the execution of the sentence of death of the person convicted of murder, Madam Speaker. I cannot agree with this, Madam Speaker, because that is in fact saying, and in essence saying, that the Governor General could decide at her discretion, and not the court, that the manner of the execution could be by hanging, could be by shooting, could be by lethal injection, or it could be by guillotine. I mean, that's stretching it a little far, but I do not think the point that I'm making that it should be the function of the Governor General. And if we look at the explanatory memorandum, it states that this is a slight amendment to enable the death penalty to be carried out in a humane manner. That may be the intention of the government and the intention of the act that the Attorney General intends. But that, Madam Speaker, in my view, is wrong, and blatantly wrong, to give any Governor General or President, if we were a republic, and I quote from the act, the power to determine the manner of carrying the death penalty. A sentence, Madam Speaker, as we know, is a judicial, and the Attorney General have said it is not an administrative matter, and I see the Attorney General nodding and agreeing with me. It is not an administrative matter, and it says the manner of execution should only, Madam Speaker, be determined by a properly constituted court, subject to and according to law. The Governor General's function should only be administrative. The next section, Madam Speaker, that I have a little concern here is Section 4.2, subsection 2, and when the Attorney General is wrapping up, he could shed some light. It suggests that there are other offences, Mr. Attorney General, than murder which carry the death sentence. Are there?
Treason.
There are other offences, treason. Section 4 generally refers to the court pronouncing sentence of death. And if you look, colleague, member for St. John's City South, at Section 4.2, it provides that all other proceedings relating to the sentence of the death shall take place before the court. This does not seem very clear to me, Madam Speaker. However, and importantly, as I said, it is apparently inconsistent with Section 4, subsection 6, which says, where a court pronounces a sentence of death pursuant to subsection, and I just stated that the Governor General shall decide the manner and the time of the conviction. Section 6 now, which the Attorney General explained, the periods of minimum imprisonment for life sentence, Mr. Attorney General, of 25 years, and for other sentences of 18 years thereafter for review, do not seem to me and to other legal luminaries and other Queen Counsels to be correct. And I say correct because we know that there is no legal objection to minimum sentences in the Commonwealth and periods to be served. But most lawyers, Madam Speaker, and most courts, especially in the United Kingdom, do not, although they were very popular before, setting in the legislation a time frame of a minimum, as we are doing today, of 18 years and 25 years respectively. And if I may crave your indulgence, Madam Speaker, just to substantiate the point that I just made, and if I may quote Mr. Attorney General from the great Judge Lord Bingham in the Privy Council in the Bellies case of Rise versus the Queen, Madam Speaker, in 2002. And the point in this comment is that circumstances of murder, Madam Speaker, vary so much that there should be no predetermined sentence such as 25 years before review. And that is only an opinion from this case from Judge Lord Bingham in the Privy Council. Doesn't mean that we have to adopt it. But I'll give for your benefit and for the benefit of the House and the Attorney General for his consideration. And it says, the penalty for murder. Under the common law of England, there was one sentence only which could be judicially pronounced upon a defendant convicted of murder, and that was sentence of death. This simple and undiscriminating rule was introduced into many states now independent, but once colonies of the Crown, just like we were. It has, however, been recognized for very many years that the crime of murder embraces a range of offenses of widely varying degrees of criminal culpability. It covers at one extreme the sadistic murder of a child for purposes of sexual gratification, a terrorist atrocity causing multiple deaths, or a contract killing, at the other mercy killing of a loved one suffering unbearable pain in a terminal illness, or killing which results from an excessive response to a perceived threat. All killings which satisfy the definition of murder are by no means equally heinous. The Royal Commission on Capital Punishment, 1949 to 1953, examined a sample of 50 cases and observed in its report in 1953 at page 6, paragraph 21, and I quote there, "Yet there is perhaps no single class of offences that vary so widely, both in character and culpability, as the class comprising those which may fall within the comprehensive common law definition of murder. To illustrate the wide range, we have set out briefly the fact of 50 cases of murder that occurred in England and Wales and Scotland during the 20 years. From this list, we may see the multifarious variety of crimes for which death is the uniform sentence. Convicted persons may be men or they may be women, youths, girls, or hardly older than children. They may be normal, or they may be feeble-minded, neurotic, epileptic, borderline cases, or insane, and in each case, the mentally abnormal may be differently affected by their abnormality. The crime may be human and understandable, calling more for pity than for censure, or brutal and callous to an almost unbelievable degree. It may have occurred so much in the heart of passion as to root out the possibility of premeditation, or it may have been well prepared and carried out in cold blood. The crime may be committed in order to carry out another crime, or in the course of committing it to secure escape after its commission. Murderous intent may be unmistakable, or it may be absent, and death itself may depend on an accident. The motive springing from weakness as often as from wickedness shows some of the basest and some of the better emotions of mankind: cupidity, revenge, lust, jealousy, anger, fear, pity, despair, duty, self-righteousness, political fanaticism, or there may be no intelligible motive at all. They went on to say, a House of Lords Select Committee on Murder and Life, imprisonment in 1989, observed in paragraph 27, paper 78, section 1, and I quote, "The committee considers that murders differ so greatly from each other that it is wrong that they should attract the same punishment. It went on to say, an independent inquiry into the mandatory life sentence for murder sponsored by the Prison Reform Trust and chaired by Lord Lane in 1993 reported at paragraph 21, and I quote, "There's probably no offense in the criminal calendar that varies so widely, both in character and in degree of moral guilt, as to that which falls within the legal definition of murder." End of quote. So, Madam Speaker, in dealing with sentencing in murder trials, this bill that we are hoping to pass today provides that the convicted and the director of public prosecutions can address the court. But provisions should be made for impact statements. For instance, the family of the murdered persons, because this is a very popular and probably good idea. I do note, though, that it says here in section 6, subsection 1A, B, that they consider whether there is any longer necessary for the purpose of deterrence, retribution, rehabilitation, the AG read out that, and in the public interest, that the convicted person should be detained. It goes on to say in subsection 6.2, a review under subsection 1 shall take into account a report submitted by the visiting committee appointed under Rule 3 of the prison rules. But I do not know, Mr. AG, whether that visiting committee would also take into consideration a family or statements by family members of the murdered person, would it? Pardon me? Oh. And they will also take into consideration statements from the family and friends and employers and so forth. Well, Madam Speaker, I'm not going to be long. I think it's a good bill. I just wanted to point out those few comments that I had, especially the 25 and 18-year rule, and think that we should leave that to the competent court, Madam Speaker, and not to legislate it here or to put it into the Act, Madam Speaker. I do not know what the Attorney General thinks about that. And, Madam Speaker, I also want to say that I've said that mandatory death penalty, it's removed here in the bill, but still minimum periods of imprisonment before review, and I think we could look at that in committee stage and see if it's better to leave it to the court and to the judge, Mr. Attorney General. I mean, why not just leave it, the sentencing, to the judge rather than us legislating? I do not know what the rationale of that is. Madam Speaker, that is my little 2 pence to add to what the Attorney General said, and I want to commend the Attorney General for his detailed and very comprehensive overview of this bill, which I commend and support, Madam Speaker. Thank you.
Thank you, sir. Acknowledge Honourable Member for St. John City South.
It's not very often, Madam Speaker, but when